insurance can be of two types, life and non-life. Non-life is generally known as general insurance. The life insurance would roughly comprise of life and or death and or injury and or illness, that is medical insurance. So some policies are simply money back. When I say money back, meaning one gets the cumulative premium of at the end of the term for which the policy was drawn out. Some policies are refund of premium with added incentive, profit based on interest or share of profit accrued from the insurance company's monies sublimated to the share market, commodities market, bonds, or other money market instruments. Now we have medical insurance. Again, has a number of schemes or types of policies. One thing should be borne in mind that there exists no consistency in the type of policies which a scheme of affairs within an insurance company or in contrast between companies. Policies can be tailor-made at times. What exactly is a policy? A policy is a document, like you have a contract between one or more persons. So also you have a contract between the insurer and the insured. Insured, of course, is the person who takes the policy, and the insurer is the company. There are various insurance companies which have a variety of policies. So what then we come to premium. What is premium? Premium is an amount of fee that is paid regularly to as a cover of a certain risk. In the event of that risk taking place, if the person who has paid the premium, whether he's paid a few premiums or he's paid the entire premium, depending on the various terms of the contract, he will be compensated. Then there is something known as cover note. Before you pay your premium, if you have entered into a contract for a policy, if you have entered into a policy, taken a policy, you enter into a contract, but for whatever reason your payment was delayed or the contract was signed, say after office hours, because this is very important in insurance. Supposing the insurance company's office hours as closing time as 6 and you have paid your money, but you don't have the policy. There is something known as a cover note. That cover note will suffice to guarantee that you have transacted the business of taking insurance. In the event of the accident taking place, suppose you register yourself or you enter into the policy and you sign the document at 6 o'clock and the company closes and therefore they cannot give you a document. Nevertheless, at 6:05 you come across an accident. So you will have to be compensated even though you don't have the policy with you. And that comes when you have the cover note. Then there is something as how you get a policy. Policies, there is a sort of canvassing going on. Something like something akin to what one would say is advertising. Actually, strictly speaking, advertising is forbidden in insurance business. But this is something akin to advertising, something akin to soliciting business, where agents go about canvassing on behalf of the company and explaining the products that they have, convincing clients, potential clients, and that would amount to insurance business. Now, this insurance business is carried out by agents, sub-agents, and brokers. Agents essentially have to have training. So various companies have their training schemes. And there is a minimum quantum of hours that have to be put into in order to complete refresher courses. But the initial course that you have to do is of some months, wherein you have to appear for exams and pass the exams in order to become eligible to hold a license, whether it's life or non-life. And thereafter, the license is renewed every year or after 2 years, after 3 years, as the case may be, by attending a refresher course. Now, as agents, you have number of, then the agents can have sub-agents as well. Sometimes it's permissible. And there is something known as brokers. Brokers are big-time agents, you can say, something like big-time agents. They deal in crores of rupees or sometimes hundreds of crores of rupees. They are sort of, you can say, like like you have a boutique law firm. So you have these brokers. They cater to a particular category of people, a particular strata of people, a particular sort of, where the business runs into crores of rupees or hundreds of crores of rupees, shipping, factories, aircraft, and such like things, or big or high value policies. Now, friends, in order to understand this, let us first know that there are 7 basic principles of insurance. Principal function, insurance functions on these 7 principles, 3 of which are the main principles of insurance. So, one of the principles will, let me tell you what are the principles. One is the principle of utmost fate. The second principle would be of proximate cause. And the third principle would be insurable interest. Now, let us take an example. The example would be like, for example, I am an employee. So, in the event of my taking insurance, in the event of my being insured, I can insure myself, my parents can insure me, my spouse can insure me, my children can insure me. A stranger cannot insure me, or somebody who has a remote interest in me, or some vicarious interest in me. To an extent, somebody having a vicarious interest in me can also insure me. There is a rider to it, to the rule. If that person has some interest, vicarious interest to the extent that they are my employer and I am the employee, then in the event of my being ill or my injuries or myself expiring or something, some losses will be incurred by them. To that extent, they can be covered. So, employer and employee can have some connectivity. One has to manifest and show the connectivity as to how they are related. Then and only then an insurance policy can be entered into. A rank stranger or my neighbor cannot insure me. That is prohibited in law, in at least in insurance business. So here I have given you to understand as to insurable interest. Now let us come to proximate cause. What is the meaning of proximate cause? Now, proximate cause, I can give you an example. Suppose an accident took place. I came across an accident and I've been hospitalized. During the course of my medical treatment and thing, and being hospitalized, something goes wrong and I expire. It is not necessary that the claim can be honored. We'll have to investigate. It will have to be investigated as to why the expiry took place and why the death took place. Because not necessarily I have died out of the injury. It could have been I could have expired not because of the injury. The injury wasn't so severe, but the operation that was done without a sterilized equipment. The doctors did not sterilize properly, or they did not take precautions for the surgery or whatever, and I could have died because of a cause other than the main injury. So I will not be compensated. The reason being, compensation is granted for proximate cause. Immediate cause of the accident did not result in my death. It was an extended cause, that a derivative of the accident. The accident took place and the accident wasn't so serious that to cause my death. But my death occurred because of the negligence or whatever other cause that was correlated with the accident. So that this settles the proximate cause. Now, insurable interest, we have to come to good faith, utmost good faith. Utmost good faith is when you're taking the policy, you have to disclose all your weaknesses, all your shortcomings, your correct age, your habits, your professional dangers involved. Suppose somebody is working in the police force. There is a possibility or someone working in the army. There is always a possibility of that man dying due to turmoil or due to some attack or whatever, in war or in some sort of defense. So his job itself is associated with such dangers that could occur anytime. Take the case of a driver. There is always a possibility of an accident because his profession is driving. So all the time he's driving. So that has to be disclosed. Then age has to be disclosed. Whether one drinks alcohol, that has to be disclosed. Whether one smokes, that has to be disclosed. Whether one has taken any other policy, that has to be disclosed. Whether one has suffered from any illness, all these factors have to be disclosed ab initio, at the time of filling the form itself. And if you do not disclose these things, an accident occurs or a death occurs, your claim can be repudiated. or declined, you can say. So these are the main things that you'll have to do. Let's take a case of non-life insurance. In the case of a non-life insurance, there could be insurance for damage of your vehicle, car. There could be injuries or death while flying, while cruising on the sea, at sea, in the air, or on the ground, on the land. So the accidents can be of aircraft, of ships, of cars or vehicles or whatever. Those kinds of accidents will be covered by non-life. Now, when such an accident takes place, a non-life, it will come under non-life. Such an accident takes place. An FIR has to be lodged. A surveyor will come. The surveyor will make a survey. He will have to visit the scene of occurrence or accident, make out a report, take statements from various people who are knowledgeable about the accident, take photographs or videographs, and make a summary and submit it to the claims department of the respective insurance company wherein you are covered. Okay, that insurance company will go into the claims and scrutinize as to whether the claim is to be honored or not. Usually, those scrutiny officers try their best to see how they can refuse the claim within the framework of law, because that is their job. They are there to save the money of the company. But your advocate will be to safeguard your interest. Since they are employees of the company, they safeguard the company from large claims or many claims. That is their job because they have been engaged there as law experts. But an advocate practicing or a firm, advocate's firm, the job would be to defend the aggrieved, that is the insured person. So you would have to defend, and your defense starts at the insurance claims department. At times, if it is not settled there, then it goes into litigation or arbitration or even negotiation. Negotiation can be done at the company's office. Arbitration can be done by the arbitrators, by a firm or an individual arbitrator, ad hoc. And litigation, of course, in courts and in the tribunal. As far as Bombay is concerned, we have a tribunal at VT, which is on Hazarimal Road, I think, Somani Road. There you have the accident tribunal, motor accident tribunal, but there is also motor accident tribunal at Thane and Palghar as well. Now, at the tribunal will file two applications. One application is for compensation, and the other is for ad interim relief. I think one is to be filed under 166 of the Motor Vehicle Act, and the other one is 164, if I'm not mistaken. For a long time, I have not been not attended this. So these are the types of applications that you have filed. In the event of accident, these two applications will be filed, but there is another category of application that can be filed, no fault liability. Now, what is this no fault liability? No fault liability is a term that is used when, irrespective of whose fault it is, whether if one is crossing the road and one is hit by a vehicle. Now, crossing the road itself is an illegal act. So, strictly speaking, the negligence was on your part. Therefore, you cannot claim compensation for injuries or death. But there is a but over there. You put a semicolon and a but. The emphasis is to be laid on but. There is a rider, because the law has been designed in such a manner that irrespective of whose fault it is, whether it's the fault of the driver or whether it's the fault of the pedestrian, 1 lakh rupees compensation is to be granted immediately in the event of death, and 50,000 compensation in the event of serious injuries, irrespective of whose fault it is. And one should not go into merit, and one should not go into argument, and there is no need for probing or scrutinizing as to whose fault it was. Whoever's fault it was, person is entitled as of right, and his right flows from a particular section to get compensated to the extent of 50,000 in the event of serious injuries and 1 lakh in the event of death. Now, this insurance business is suppose you die. Who is to put your claim? Well, your parents, your spouse, your children at the most. It does not, at times it does not extend beyond your children, the in-laws or something like that. That there's a very big question mark over there. And these matters will be decided by the courts, because at times there have been a lot of confusion as to whether in-laws and distant relatives can claim. compensation. So then we come to, let me take you briefly to admiralty laws. Admiralty laws deal with cases of accidents in navigable waters or involve contracts related to commerce on such waters. Now, why I use the word related to commerce on such waters? Navigation can be done at the ocean, at the high seas, or in territorial waters of any country, rivers, creeks, or otherwise any water body. It could even be a lake. Suppose there is a lake and some fishing is going on there, or some tourism is going on there, and people are in a boat and something happens, boat capsize or sinks or whatever. In such an event, the people who have been insured, this policy will they will come under the nomenclature of this admiralty laws. They will be governed by this in such accidents. The jurisdiction of territorial waters of a country would mean what is the jurisdiction of it extends. Suppose that what is an admiralty jurisdiction in India? If the question arises, it extends to Indian territorial waters. Now, territorial waters are counted in nautical miles. What is admiralty jurisdiction in CPC? If something like that arises, some such question should arise. What is admiralty jurisdiction in CPC? Now, admiralty law and its jurisdiction have been kept separately from the ordinary civil jurisdiction. Admiralty jurisdiction will, as per CPC, there is a provision in CPC right now. I have not got that, but the CPC is very clear that it does not have, it does not cover admiralty jurisdiction, where there is a conflict of law of a civil claim in a civil court. Admiralty law will prevail over CPC. It has a special jurisdiction, and therefore, by section, what is that section? I can't get that section. I don't remember it. If there is a dispute of two laws, usually whenever there is a dispute of two laws in any dispute, whatever the nature of the dispute, common law shall have precedence. It's the other way. The special law shall have precedence over common law. So in this case also, CPC is a common law. It's applicable to most of the other substantive laws. But admiralty being a special law will have precedence over CPC. Now, this admiralty thing is a very lengthy subject. Sometimes ships can be seized for non-compliance of orders of courts. Usually the High Court looks into this and the Supreme Court. Courts subordinate to the High Court, meaning the Magistrates Court and the Session Court, don't look into the matter. They don't have the jurisdiction to look into the matter. They don't have the statutory jurisdiction to look into the matter. It is usually the High Court and the Supreme Court that looks into it. But other kind of disputes, car accidents, fire, crop insurance, and theft, robbery, assault, all these things, injury by assault, all these can be looked by magistrates courts or tribunals or even session court or ordinary civil court. But matters pertaining to admiralty are exclusively looked after by the High Court and the Supreme Court. Now, High Court has certain inherent powers. Inherent powers in the civil capacity it also has in its criminal capacity. On the criminal side, it will be 482, 483. In the civil side, it will be 151, 153. But apart from that, the High Court also has writ jurisdiction, 226 to 227. And by exercising these inherent powers that are vested exclusively by the Honorable High Court judges have taken upon themselves to pass such orders as so as to impound a ship or take some of the staff into custody for some wrong that they might have done. The shipping administrative staff of the ship can be taken into custody. Then they will have to be released on bail, or the agents in the respective country will have to be arranged for them to be enlarged on bail. The ship can be sort of, something like we say, anchored and in a dock and prohibited from leaving the waters. So there are this sort of orders can be passed by High Courts and Supreme Courts. There have been times when ships have been, High Courts have taken issues of employees of the ship. non-payment of wages or employees, ship was impounded in a particular country. And thereafter, the law takes its own course. Now, this claim, suppose the claim is a small claim, an accident claim. Sometimes the claim is admitted, accepted, sometimes is partially accepted, or at times it is repudiated. That is in the claim. That is in the claims department of the insurance company itself. If the person who is insured is dissatisfied, she may go to court or a tribunal. But there is another option. There is also an ombudsman, which we have in other avenues. Also, we have ombudsman in banking and certain other avenues. Very few people approach the ombudsman. One can go to an ombudsman and put their application there. Claims can be litigated, arbitrated, or negotiated. Now, this insurance business is, as I said, people get training. There are a number of insurance companies nowadays. Private companies are there, foreign companies are there, and you have nationalized insurance companies. There are 4 large nationalized insurance companies. Earlier, if I'm not mistaken, in 1971, Indira Gandhi had nationalized all insurance companies. That was a time when not only insurance companies, but oil companies and various other banking companies got nationalized. So also the insurance company, shipping companies and insurance companies. Insurance companies got nationalized, and only 4 Indian companies were allowed to practice, allowed to do business in India. Thereafter, now again we have opened the frontiers, and foreign insurance companies have come in. Some private insurance companies are there, some are limited trading shares on the market, etc. And there is something known as insurance and reinsurance. Now, why should there be reinsurance? The insurance business runs into thousands of millions of dollars worldwide, and all are related and interconnected with each other in all countries, so that we can minimize the loss. Let's suppose a particular insurance company has taken as issued insurance to the extent of some 1,000 crore rupees. In the event of some serious accident taking place and so many people dying or so many buildings collapsing or whatever, that company will not be in a position to pay all the insured. It will run into lakhs of crores of rupees. Therefore, insurance is to an extent reinsured. Part of the insurance is reinsured with another company. One insurance company insuring with another insurance company. One Indian insurance company insuring with a New York insurance company, with a Japanese insurance company. Why? Because in the event of any accident taking place, the liabilities will not be only of the Indian insurance company. The foreign insurance companies will also have to contribute towards the liability, acting as a buffer, so that the losses incurred by the original company that granted the insurance is not so much that it goes into liquidation. It's just a safety measure. Now, insurance companies take your money. Some of them utilize the money. Obviously, they are going to utilize the money. How else would they be in a position to give you compensation had they not been able to utilize your money? They utilize your money sometimes in the stock market, sometimes in the commodities market, sometimes by instruments, government bonds, sometimes by various other instruments, and sometimes by lending, okay, short-term lending or whatever. So that is the profit that they accrue from your investment. When you take a policy, you pay a certain amount of money. Sometimes the policy is such that you only get a refund of what you have paid. Sometimes you get a refund which includes interest. Sometimes you get a refund which includes interest and a slight profit of what profit has accrued to the insurance company with the monies that they have invested in certain projects, construction projects or whatever. So those policies are known as I can recollect only one as of now, ULIP. One company had a policy known as ULIP. It is some units were given allotted to you, and you have to sort of if those units appreciate, if the profits of those units appreciate, that profit is shared with the policyholders. Just like if you have in a company, if the price of a share increases, the profit what they're getting above the actual price of the floor price of the share, that profit is given as dividend. So this is something akin to dividend. You can take it as something akin to dividend. Insurance, there is nothing in this world that cannot be insured. See, you have insurance for animals, insurance for spacecraft. Spacecraft meaning people are not going to travel in the spacecraft. But if the spacecraft should crash and in a city and people are injured and damaged property and damage to life, then compensation is to be given by a government for which insurance has already been taken. You see, so there is insurance for everything. Even your crop doesn't grow in a particular season due to want of rain, that also can be insured. Anything and everything under the sun can be insured. If there isn't a policy for it, a policy can be framed by sitting down with the development officer, because they have a hierarchy: agent, development officer, then there's a divisional officer. They have go on and on until finally you come to the zonal manager. So they have their own hierarchy. So these are some of the things, thoughts that I wanted to share with you on insurance. It should be remembered that, again, I'll come back to the old thing and say that it should be remembered that insurance is not for profit. Insurance, I cannot take more insurance than what I am worth. Let me give you an example. Suppose I am a person who has done just SSC, or I am not educated at all, and I am about 80 years old, and I am a person who lives on the footpath. I cannot go and take insurance to the tune of 20 lakh, 30 lakh rupees. That insurance will not be accepted, and if it is accepted, it will not be honored at the time of claim. Because a lot of things have to be considered as to how I got the money to insure myself, why I want to insure myself for so much money. All these factors will have to be considered. Insurance is not a business where you go on sort of with speculation. You can insure what you are actually worth, and you will be compensated what you are actually worth. If I am worth just 10,000 rupees, I cannot insure myself for 10 lakhs. If I want to insure myself for 10 lakhs, I should be worthy of insuring myself for 10 lakhs. I should be educated. If not educated, I should be a businessman having that much of assets. If not that, then I should be some actor or something where if my body is damaged, it will I can envisage a loss of rupees 10 lakh if my beauty is or something. Or if I'm an advocate and I get injured on my head and I lose my memory, then as an advocate, what would be my income, approximate income, and my age also factor has to be taken into consideration. How much I would have earned. Suppose an accident takes place at the age of 28. The average span of man life has to be computed when computing the claim. What is the average lifespan of a person, human being? So that person would have lived that many years. So what would have been his average income? That is to be taken into consideration. His age, how much age, his strata of society, etc., etc. All these factors have to be taken into consideration when computing the claim. So also in accident insurance, we have tabulated claims. They have a sort of picture, tabulated claims. If one finger is amputated, how much you get? If one hand is amputated, how much you get? If a leg is amputated, how much you get? If the eye is blind, how much you get? If it turns blind because of some accidents, how much you get? If the face is disfigured, how much you would get? Burning, a person is burnt, how much you will get? So all has been tabulated. So these are the few things that I wanted to share with you.
So actually, Edrich, they have their exam on Tuesday. Can you focus on fire insurance and what are the causes? Do you have that material on you?
Some rough idea I have. See, fire insurance, suppose if a fire takes place, then the fire brigade they have to file a report. The police will have to file a FIR. The hospitals will give a report, what you call medical legal report. That medical legal report will show as to about the injuries to persons who have been injured due to the cause of the fire. So you will get a medical report. You may, if somebody has died, then there will have to be a forensic report. But there can be various other reports. Then the question will arise as to how the fire originated. So sometimes you may even need to have a forensic report of a cyber type of forensic, because the fire could have been originated due to automated machinery, electronic equipment. So there can be various type of inquiries. Police inquiry will be there. Fire brigade will conduct their own inquiry. Everybody will give the report. In spite of all the reports, somebody will come from the insurance company. He is known as a surveyor. So he'll come and make his own report based on various things, checking the fuse, checking the size of the cables, checking as to whether it was short circuit or whether it was overload. Because people who have got electrical background, they will understand if a fuse has gone, whether that fuse has been blown off due to short circuit or due to overload. If it blows out of overload, it will merely melt and break circuit. But if it is out of short circuit, it will blast and they will find small granules inside the fuselage. So there are various ways of governing as to what happened, how it tripped due to overload. What was the overload? How did they not compute the quantum of electricity that would be used in the industrial estate? That factor will come again. So when when electrical engineers are computing as to what will be the maximum load, they are supposed to count the load, maximum load, 100, and it should be doubled into 100% of the fuselage should be, and the cable should be in a position to carry 100% more than what the actual full load is. That is for Indian, something what you call Indian standard specification or something like that. So you have to compute not only the actual load, 100% of the load, then you have to compute even temperature rise. Then you will have to compute voltage drop due to distance and due to material that is used, whether copper was used as a cable or whether aluminum was used as a cable. Then the distance of the voltage drop due to distance, all that will have to be computed, and then only the claim will be settled. So these are some of the things that in different professions have different people investigating fire would check. They will say, when they send a surveyor, he is a person who has knowledge of electricity because or other chemicals and things like that. So whether the fire was, sometimes the fire brigade itself is the cause of the fire, a cause of more damage. Now somebody might ask me how. If a fire takes place in an industrial estate and certain material is stored in that estate in drums, calcium carbonate or something like that. In such a situation, the fire brigade or whoever is in charge of taking care of that place should never pour water, never spray water. The moment you spray water, there will be an explosion and you will create more damage than you are going to save. So you should be well trained how to look after fires. So these are the things that we know in certain other fields. In medical field, people specializing in medicine will be investigating. So this is it in short. In shipping, somebody who knows engineering and somebody about shipping, that person will investigate as to how the ship sank and why the ship sank. So sometimes ships sink in rough sea because the cargo shifts or because there is a vacuum. Some of the ship cargo has been offloaded at some port, and that is a vacuum for the ship. So the ship sways uncontrollable. In such event, it is the duty of the captain of the ship to pump in air to maintain its balance, or pump in water to maintain the balance of the ship. So these are things that are specialized, and only people in the profession connected with that particular profession are aware of it, and they go about doing their job.
Edrich, there's one question by a participant. When drafting a contract for an insured, okay,
Yeah.
for the insured, what clauses should the lawyer keep in mind?
There are standard formats. You cannot draft your own. Usually, there is a sort of format, and you fill in the blanks. Your agent helps you to fill in the blanks, but you are supposed. Let me make one thing very clear here, which is not taught in the school and college, but it is taught with the agents. Agents are taught this. Agents can assist the person to fill a form, but they should never fill the form in their handwriting. See, you can assist your customer or client to fill the form. The forms are of a particular format only, unless if it is a specialized insurance which is not existing and you're making a tailor-made policy, then you'll have to sit down and draft your own.
Okay. Edrich, if a person is missing, okay, this is a hypothetical situation that I'm asking you. A person is missing, has a life insurance policy, but his whereabouts are not known for 2 or 3 years. So the family, do the beneficiaries have to wait for 7 years, or they can, is there any provision? Do you have any idea?
They have to get an order from the court. The insurance company will not release the monies.
Until 7 years, right?
But you have to, he has been insured for what? For death? You
Yeah,
will have
for
to,
death.
that will again become a dispute as to whether he is dead. He's declared dead, assumed to be dead by court as a, from a legal point of view. But whether he is actually dead or not, that can never be conclusively established.
Okay, so it's only after, if it's not conclusively established, so only after 7 years they can, beneficiaries can claim.
Well,
Or the court will.
law is such a subject that nobody can do anything. Nobody can give a definite answer for anything.
Okay,
Today the court takes a view like this. Tomorrow the court takes some other view. Depends upon who is the honorable learned judge sitting there. What is his temperaments? What is his education qualification? What is his likes and dislikes? And what he appreciates, what evidence, or he may appreciate something, he may not appreciate. Now we cannot,
a definite, yes.
yeah.
Yeah, there's no definite answer to this. If a natural tree can be insured.
Tree.
Yes.
I wouldn't be in a position to answer this, because these things you can find out from insurance companies, because there are some policies that they insure, they accept, or they make it particularly tailor-made policy for something that they don't usually have. So nothing prevents you from insuring even cow or
No, so see how crops are insured.
yeah,
So
crops are insured.
similarly, can a tree be insured?
Yeah, I think
A mango tree, an apple tree.
I don't think there should be any difficulty, because if they're issuing insurance for crops and for plantations, so why should there be any difficulty? Then we sit down with the development officer and draw out a policy accordingly.
Okay, so crop insurance, can you highlight something so that will give us an idea, like the jurisprudence on this?
Crop
So maybe
insurance.
the participants' query with regards to the tree might get little bit resolved.
Crop insurance is the insurance that is taken for a particular season of the crop, or whatever seasonal crop, or otherwise any other type of crop. And if it is eaten by locusts, or if it is if monsoon doesn't come in time, and that plant or vegetable dies, and you will be compensated. But you have to establish that monsoon did not arrive in time, or there was inadequate water, or locusts came, or some other or rats, or something happened. For fruits, it could be you can blame the bats or ants, and for crops also you could blame some sort of some locusts or some other thing that come, some bacteria or something comes and the crop dies. So you get your compensation.
Okay, okay. There's one more question, that the insurance companies, most of the insurance companies in India indulge into practices where they take very long to settle the claims. So what would your advice be? What can the law fraternity do, or common citizens do to stop this practice?
Yeah, actually, I would not be in a position to answer this question, not because I cannot answer it, because I am prohibited from answering it. When we become agents, we give an undertaking that we will not do anything in derogation
Yeah,
of
say
the company.
against. Yes, yes.
Yeah.
But Edrich, why is it that they indulge in this practice?
All business people are in business to earn money. Okay. So
Yeah.
nobody wants, if they can decline a claim, so much is the profit of the company. You enhance the profit, you get some production bonus, or you get some incentive, or you get some promotion. So everybody wants to show progressiveness. I save so much money for the company, therefore I've been elevated. This goes on everywhere.
Okay, but would there be a legal advice that you can give? A writ, can a writ be filed, or a consumer? Of course, we can. Can there be we might have to consult a consumer lawyer for this, but I think even a consumer complaint can be filed, right? For
Consumer
delay in
complaint,
service, deficiency. Yeah.
delay in service, that consumer, but if it is a public interest matter, then it might go as a writ only.
Okay.
If you want to change the law or something like that, or then a case law will come to be sort of, after matters agitated before, agitated on merits in its entirety before the Honorable High Court or Supreme Court, and then law comes to be passed, that will be a case law. that may help to regulate this misconduct. But companies are not going to give in so easily. That is a bread and butter. It is sometimes it is the advocates themselves who do procrastination by deliberately not filing the proper written statement or keeping written statement to be filed even after 1 month period. Actually, the CPC has been amended and they are supposed to file a written statement within 1 month. But it goes on for 6 months and 8 months and 1 year with no one admonishing them. And therefore, they are irregulated.
Okay. Okay. So, Edrich, there's one more participant asking a query. We'll unmute the participant.
Okay.
I hope we can continue.
Yeah, we can continue, no problem.
Okay.
Hello. Hello.
Yes, sir.
Am I audible?
Yes, sir.
Yes, Edrich, this is Advocate Ajay. As per the prior question that I wrote on the chat, that ensuring about the natural object, like when it comes to ensuring about like a tree or if a tree like if we have planted it before us, so that could be insured. But what about like the natural object which is of a 100 or 200 years old, or which is of a kind of a heritage type, or like a well, an old well or something like that of a heritage thing? Can we insure such things which are natural in its origin, or like which have its existence of some heritage kind? So are such things like permissible to be insured, or do we have such provisions in law?
Now we'll have, may I take you back to the insurance, what you have, the principles of insurance.
Sure, sir, sure.
If you want to insure something, that's up to you. You said you want to insure some old tree, a tree that is 100 years old. The point is you have to show what is your locus standi. Do you have right title and interest in the tree? If it's not your tree, then how can you insure it? You have to have the title to the tree. Have you planted it? Is there any documentary evidence that it's yours? Is it on your property? Something like that. Something should be there. Otherwise, how can you convince the company, that this is my tree? Somebody else will claim this is my tree. So first you have to establish whether it's your tree.
So in that case, suppose if the tree is situated on the land owned by my client, so then he can claim for the insurance of that particular tree.
There is some palpable evidence that the tree is obviously his because it's on his land. Then other questions may arise. And so what is the value of the tree and how much you're going to insure it for? Because if the tree is valued 50,000, 1 lakh rupees, or whatever is the value that you have arrived at by calling a valuer.
And then overall health of the tree may also be taken into consideration, whether how long
many factors will go into consideration.
Exist, or sure. And means such provisions are there, and
yeah, I said tailor-made policies are there available. We do not have to strictly go according to the existing policies.
Sure, sir. Thank you so much, sir, for replying that. Thank you.
Welcome.
Okay, so Edrich, we move on to the next participant.
Yes, please.
Was one query about the delay about settlement of insurance. So I just wanted to give one small comment that I take care of the health insurance underwriting part. So most of the policy contracts, if you see in India, they are with a clause like within how many days an insurance company will settle a claim. It is written in case of once the documents are submitted, or if the claim undergoes investigation. This is normally in India, it is 30 days if you serve once you submit all the documents, or if the claim undergoes for any kind of investigation for any suspicion of fraud, then it is a 45-day time period for the insurance company. If they don't settle it within this time period, then the insurance company is liable to pay 2% interest on the normal prevailing interest given in the bank. So this is just one point I wanted to share with the participants. Thank you.
Thanks for enlightening me on this, because I was not aware of this 2% to enhance interest. I think that's recently only it has been introduced.
So I already have internal along, and things are quite clear and transparent. So insurance industry is right now a very highly regulated industry in India in comparison with other countries.
By IRDA.
Yes.
That's a regulatory body for insurance.
Right. Thank you.
Yes.
Okay, sir. Thank you so much. Any more queries, participants? Edrich, do you have material on the Motor Insurance Act handy, or do you have any rough idea?
Motor Insurance Act.
Yes.
When I'll just give a short this thing. When an accident takes place, vehicle accident, two cases come to be filed. One is a criminal case for rash and negligent driving. I think that's 188 of the IPC or something like that. Or Motor Vehicle Act, something. One rash and negligent driving. One is a criminal case, and one is a monies claim. And the monies claim applications are of two type again. One is for immediate relief, and one is for eventual relief. After going through with the evidence and completing the entire trial, then you get your compensation. But prior to that, you get an ad interim relief of 50,000 or lakh or whatever or something you get as an interim relief. So you move two applications. One is for complete compensation at the tribunal, and one is for interim compensation. And the criminal case also goes on at the criminal court. So when an accident takes place, a vehicle accident, you want the information on the criminal side of the case, because two cases take place now. When motor vehicle accident takes place, two cases will come to be filed in the event of an accident, depending. Now suppose two vehicles crash, FIR has to be there. Or if a vehicle runs over somebody, then also FIR is to be done. That FIR will be conducted in a magistrate's court for rash and negligent driving as per IPC. So that's the criminal aspect of it. And the civil aspect of it is the compensation. That will go on before the accident tribunal. There again, civil application will be two applications. One for final relief of compensation that you're seeking, and one for interim relief. Does that satisfy, or you want the detailed listing?
Sir, there was one query that one of my relative is have taken a health insurance policy, which is policy companies provide some cashless claim to a selective hospitals. At the time of taking a policy, they have conducted some health test and they found suitable. Then they granted the particular health policy. On a third year, the particular claimant, the wife has admitted in a particular hospital. Where the hospital has raised the claim to a company, but company has not initiated the process. Thereafter, within around 8 to 10 days, due to a critical illness, wife expired. And right now, as one of my colleague has indicated that the 30 days and 45 days period is to settle the claim, etc. So they have raised the hospital, and my client has raised the claim. Thereafter, the insurance company again and again keep on repeatedly asking that you have not provided the sufficient document, and the hospital doctors are in middle of the path. They have provided each and every document from day one, pre-care to day of admission till the final discharge, everything, summary, etc. The insurance company keep on lingering around for the 6 months. Total claim is around 12 lakh. And right now, when the client has raised the complaint to IRDA, they have admitted the claim and processed the claim for only 5 lakh. So can my client go for the consumer complaint for the such amount?
Yeah, you can go. What prevents you from going for a complaint?
Because that
On what ground they have this thing? On what ground they have reduced the amount, or
they have not given any explanation. My client still now more than 6 communication have addressed to insurance company to give the details that previously on what ground you are rejecting the claim, and simultaneously at now you have admitted the same and by reducing such huge amount. So they have not replied any of that query.
now if you go to court, now you are an advocate yourself, correct?
Yes, sir.
Then you will be knowing. I mean, I guess you are aware of how to handle this matter.
Yes, sir. But
If you file whichever court it is, whether it's consumer court or any court, if you want to call for documents, now suppose if it was a criminal matter, then you could have called for documents under section 91.
Yes, sir.
And they will have to produce when the court asks for it. So
yes, sir.
we have a similar procedure in the CPC also.
Yes,
where documents can be called from any authority. and they will
Yes,
move an application for calling of documents, and the court will serve summons on the insurance company. They will have to produce the documents.
yes, sir. I just want to justify that whatever the advice I have given, that was confirmation from your point of view. That's why I put my query. I have advised that you move for the consumer code for the harassment and keep on lingering for more than that specific period which is provided under law. So this is a kind of intentional harassment, because right now, and it is not the one case. It is a kind of numerous case. The health insurance company, which are mostly giving a cashless that claim service, this kind of particular harassment done by them in most of the cases.
No, if you're depending, you want to inspect the documents and how they came to conclusion that the amount is 5 lakh.
Yes, sir.
That they should sanction only 5 lakh.
Yes, sir.
So that the documents can be called for in any case, whether it's criminal or whether it's civil. How to call for documents, CPC is very clear, and CRPC also is very clear.
Yes, sir. Okay, thank you, sir.
Sir, as per principle of utmost faith, the insured should disclose all the information at the time, insured, like at the time of taking the insurance. So, but there might be a few situations where the later point of time, the insured get to know the new information about his ailment. Like he might get a new ailment, new medical ailments. In such a situation, what should the insured can do?
At the time of taking the policy, he wasn't
Aware of anything.
Yeah, this didn't exist, that
Yes, sir.
illness. So
Yes, sir.
after the policy is taken, nothing can be the thing. The insurance company will have to base it on the policy that was. They have to admit that he was okay. They are stopped by the rule of estoppel. If you look at the
Okay.
Evidence Act, there
Yes,
is a
sir.
rule of estoppel. Once you have entered into a contract, thereafter you cannot amend the contract. So they have to
Okay.
abide by the contract that he was okay physically, mentally, and all. He was okay. It can be presumed that he was okay.
Okay, sir.
I think it is
Then-
section 115 or something, 111 or 115 of the Indian Evidence Act 1872. So see between 11 and 15, somewhere there.
Yeah, but Edrich, even if there's a new development in the health condition, still it cannot be amended.
No need to amend. You are on a safe footing, no? It is they who need. It will be advantageous to you by not amending. Why should you amend? I have
Yes.
already entered into a contract. My contract is signed. And what develops pursuant to a signature, appending my signature, I cannot envisage.
But the
But
insurance
intent-
company might take a stand that I didn't disclose the fact, or
Yeah,
I-
intentionally
I-
they may
I-
liquidate my
I-
claims.
On this point, I'll clarify on this point. Actually, if I was appearing, my stand would be that the company is required to trace out any irregularity within a period of 1 year. After 1 year has lapsed, if they point out any irregularity, they are barred. So it was a duty has been cast on the company to find out any irregularity in my form. Having failed to find out anything for a period of 1 year, they are barred in law. The question doesn't arise. Got it?
Okay,
Yes,
Edrich,
sir.
and if intentionally the facts were not disclosed, then
Even then, if I intentionally did not disclose any facts, it was a duty was cast on them. There are various rulings from courts that and the law is such, because not only the insurance law, it is to be read in conjunction with the insurance rules. So the insurance rules bars the insurance company from raising any defense pursuant to 1 year.
So, sir, the duty is on the insurance company, but not on the insured.
It is
But
on the
why-
insurer also. He should disclose all facts. Okay.
Okay, sir.
But there is a binding on the insurance company that if they do not find out any weaknesses or any discrepancy within a period of 1 year, it is deemed to be admitted. The policy is confirmed. They cannot take a stand afterwards that you did not disclose.
Thank you, sir.